tuned in to The Andrew Lawton Show.
To get back to the COVID file here, I mentioned earlier on in the program the issues we were having with trying to have some level of accountability for what the federal government did over the COVID era. And I mentioned that bill that Pierre Poilievre and the Conservatives have gotten behind, Dean Allison's private members bill. And this is a bill, Dean Allison just like retweeted me 1 second ago. So I didn't know if he was listening to the show, but he was retweeting me in my comment about what I was just about to bring up here. The Liberals are displeased that anyone is trying to muck around on their record. We saw one tweet from Seamus O'Regan, which accused Pierre Poilievre of wasting time. Pierre Poilievre tabled a bill to ban vaccine mandates. Today we have to waste time debating it. Oh yes, heaven forbid you have to debate legislation and policy. That's what Poilievre wants to talk about right now. Not affordability, not inflation, not housing, not what's happening in Europe or the Middle East, vaccine mandates. Well, my comment to Mr. O'Regan was that perhaps he wouldn't need to waste time debating your government's egregious violation of civil liberties if you didn't egregiously violate people's civil liberties. And then Mark Gerritsen decided to weigh in with his own comment on this to the same sort of effect there. The anti-vax club. That's what Poilievre is talking about right now. Not affordability, not inflation, not housing, not the war in Europe or the Middle East, vaccine mandates. Did that sound similar to the other tweet? It's almost as though they just got like a fresh batch of talking points sent down the pipeline from the PMO, and they're all just copying and pasting. Now, if Pierre Poilievre were truly debating something irrelevant in the House of Commons, he would be debating Mark Gerritsen. But that is not what was happening. He was talking about vaccine mandates, which affected millions of Canadians, and not only the individual people, but affected the core civil liberties and right to make individual medical choices that all Canadians enjoy. When you attack the freedoms of one Canadian, you attack the freedoms of all Canadians. And it is noteworthy that the Liberals do not want any real scrutiny of their record, that they don't want to rehash this, that you see the government so fervently telling everyone when there are court cases up that, oh, we need to dismiss this, it's moot, we can't talk about this, we don't need this, because they don't actually want people going back to that 3-year period of 2020 to 2023, really, and seeing the extent to which these policies did break the law, did violate people's rights. They don't actually want to have that discussion. And it's kind of interesting. There was that call from, I believe Emily Oster is her name, a writer last year for pandemic amnesty, which was basically, yeah, we all said some things, we all did some things, it sucks, but it was a difficult time. Let's all just move on. Let's just, let bygones be bygones. And it's a lot easier for the people who were responsible for some of the violations of people's rights to call for pandemic amnesty. It's very similar to Hamas attacking Israel and then calling for a ceasefire, as if to say, okay, we hit you, now we just want to stop. We just want to get rid of this all. But that's kind of what's happening here. The people that are calling for us to move on and never look at this again are the people that were very directly involved in the reasons we should look into this period. Joanna Barron is the executive director of the Canadian Constitution Foundation. Her colleague, Christine Van Geyn, is the CCF's litigation director. The two have a fascinating piece in C2C Journal about this, and an even more fascinating book that is coming out in the next few days here called Pandemic Panic: How Canadian Government Responses to COVID-19 Changed Civil Liberties Forever. They don't want to move on from this without a deep dive into all that went wrong and perhaps setting out a roadmap for how to avoid this in the future. Christine and Joanna, wonderful to talk to you. Thanks so much for coming on today.
Thanks for having us on.
I mentioned a couple of moments ago, in court cases where these restrictions are coming up, we're often hearing from the government's lawyers these appeals to mootness. It was kind of this just little moment. It was almost like the Twilight Zone. It's not really where we are now, so there's no point in dealing with this. They've had some success on that, notably in the travel vaccine mandate case, although it stands to reason what's happening with the Federal Court of Appeal there. But let me just ask you on that, why is it important to not just let this era be put in a box and stowed away on some back shelf?
Well, I don't think that you've seen in recent memory an extraordinary, areas of life, just an extraordinary array of areas of life that we never imagined the government could start regulating in: health, our social lives, our religious lives, our expressive lives, pretty much you name it. And if we can't go and see how our judiciary, how our politicians, even, because politicians ideally should use the charter as a sort of guardrails for their behavior, if we can't have an honest accounting of how we fared at this stress test, we are certain to see other public health emergencies, pandemics, who knows what other nature of thing in the future that will affect all of those domains of life, and we're doomed to repeat it. So, as you rightly noted, we opened this book by being sort of against the pandemic amnesty. No, we can't have amnesia about all these things that happened.
I'll ask you about this, Christine, as well, because one of the challenges here is that there's a legal aspect. And I know you're approaching this book as two lawyers, and a lot of your advocacy on these issues has been through the legal lens. There's also the political aspect and the cultural and the media aspect. And I'm curious how much you think this is really a legal question versus a political question.
Well, it's a legal question because a lot of these issues were addressed by the courts. But I think there's also a political question as well, and also a cultural one. And one of the things that we noticed in writing this book was how the culture around civil liberties seems to have shifted really dramatically. I think that there became this pendulum swing towards expediency and towards deference among the members of the public to government decisions that didn't quite exist before. I think we were more skeptical of state power before the pandemic. And during the pandemic, it seemed like there was only one way that you could think about government restrictions, and it was to wholeheartedly celebrate them, even when they violated some of our most fundamental tenets of our Constitution. These things are all interconnected, right? The politics, the culture, and the court decisions that come out of it. And it kind of operates in a cycle. And now we have a number of pretty terrible precedents legally where courts evaded judicial scrutiny of rights violations through procedural reasons. Mootness is one example that you gave, and we dealt with mootness a lot. Another example is standing. There were cases where cases were dismissed for lack of standing. And the really important and novel questions about our rights in the context of a unprecedented crisis were never resolved. And if we don't resolve those issues from the courts, we don't have good precedent to protect ourselves against intrusions in the future. We don't have everything resolved, right? We're still waiting for some decisions. We had to put the book out at some point. I actually just received my copy this afternoon. Was happy to see your endorsement on the back there, Andrew.
Oh, I'm happy it made it to it. I'm glad it was useful.
but yeah, it not everything is resolved. In particular, we're waiting for the result in the Emergencies Act invocation judicial review, which we had brought. And we're expecting that maybe in the next few months.
Let me actually ask you, I'll start with you, Joanna, but if you want to bring in your own perspective, Christine, please do, about the Emergencies Act, because some of the government's arguments on trying to dismiss these challenges have been insane. And one of them, I'm crudely paraphrasing here, is basically, well, this was a once-in-a-lifetime fact pattern, so therefore, there's no point in really, having it out, because the next time the Emergencies Act is brought in, it's going to be under different circumstances. And that's a really dangerous argument, because every case has its own unique facts. And the point of precedent is not that you have a one-size-fits-all solution, but certainly you start defining this. So the fact that this never-before-used legislation, the Emergencies Act, came in, we've never had judicial guidance on how to use it, and the government doesn't want that, is incredibly concerning. Have I misrepresented anything there, Joanna?
No, certainly not. And I would add that in addition to the government pointing to the so-called unprecedented nature of the Freedom Convoy, as you say, it's not clear to me that there couldn't be some other type of emergency. We have climate issues. We have global security issues. The world is a dynamic and changing place. But the important thing to add, even beyond speculation, is that at the hearings, both at the Public Order Emergency Commission hearings as well as the judicial review hearings, the government very specifically and very stridently, I would say, pushed an interpretation of the application for the Emergencies Act, which would give them very wide ambit to act. So specifically in the Emergencies Act, which defines threats to the security of Canada in a way that's linked to the CSIS Act, and that thus, relies on a CSIS assessment, an independent assessment, specifically to avoid concentrating too much power in the hands of the executive. We heard the Prime Minister himself directly say that his government's interpretation of that was that he could declare a state of emergency throughout Canada based on his understanding of threats to the security of Canada as the governor and council, independent from any external threat assessment. And at both hearings, he declined to provide any type of legal brief, legal memo, let alone external threat assessment, which we know from the testimony of Jody Thomas was never provided. So actually, if that standard rules the day, Justice Rouleau seemed to accept that. And we know that the federal government, which is going to be bringing forward proposals for amendments to the Emergencies Act, they're going to seek to separate out the CSIS Act definition so that basically the Prime Minister can decide when an emergency exists. That would make it even more common that something like the Emergencies Act could be invoked again. And perhaps Christine will talk a little bit about what that actually meant throughout all of Canada, not just Ottawa.
Yeah, it is important to remember that when the Emergencies Act was invoked, it wasn't geographically limited. The Prime Minister had said this is short, this is limited and temporary, but it was not limited. It applied across the country, even though by the time it was invoked, the protests were only taking place in Ottawa. Quite literally, as the Emergencies Act was being invoked, the police were in the process of clearing the border blockades at Coutts, and the blockades at the other border locations had already been cleared. I think one of the interesting things that the book does, though, is it looks at this from a approach of constitutionalism and it places a premium on the values of the rule of law. And look, we're not here to cheerlead the convoy. I think that the convoy accomplished the political goals that it set out to accomplish, but certainly there were aspects of that protest that were illegal. And we have a whole chapter in the book about the rule of law and the value of the rule of law. And we hold the federal government to the standard of the rule of law. They can't invoke legislation when the legal threshold to invoke is not met. They don't have this extraordinary power unless they're authorized by law. But on the same hand, we need to hold members of the public who participated in the convoy to the standards of the rule of law as well. And certainly there were illegal acts that took place. People should face criminal charges related to those criminal acts. And certainly a protest cannot go on indefinitely. By the end, the police were certainly entitled to exercise ordinary police powers to move large vehicles off of streets, not to permanently block a protest from proceeding. I think there's no question you can protest on the lawn of Parliament Hill, but you certainly can't indefinitely block Ontario highways. There's provisions of the criminal code that address that, though, and there was no need to resort to the use of the Emergencies Act. So I think that that's one of the things that is going to challenge readers in our book is whatever your perspective on this, on all of these issues, on COVID, on the Emergencies Act, I think you need to be prepared to have that perspective challenged because these things are not straightforward. Whatever the mainstream media might say, this is not a black and white issue. These issues are complex. And that's why we required an entire book that took us years to write to go through all of this. So I encourage anyone who reads the book to read it with a very open mind because we really have spent a lot of time trying to get the balance right on all of these issues.
Well, one of the things that you have both done in this, which I was very grateful for, is you've gone right back to the beginning, because I think when the convoy and the Emergencies Act came in, we're talking about now more than 2 years after the onset of some of the earlier COVID restrictions. And some of those early stories that almost sounded quaint in comparison of like, some kid, given a citation for using a public basketball court. Or I remember there was one in Hamilton where a drug dealer was arrested for operating a non-essential business. as well as for dealing drugs, like some of these things, which almost became novelties. But the reason they did is because the government response to COVID got more and more severe. At that point, we didn't know we'd be looking at church closures, pastors in jail, family gatherings being, in some cases, raided by police. And all of these things, are too large to just say we can't look into. And I'm curious what your thoughts are on the procedural aspects here, because I know there have been a lot of these charges that were issued that have just been dropped because of judicial resourcing. We don't have enough time to go through 3 years of fines. Courts are backed up. The problem with that, of course, is that no one has had their day in court. The arguments and the precedents haven't been made. But for the individual people charged, it's a win. So how do you reconcile those two?
I think we had one case that was like that that we talk about in the book, and it relates to an individual protester in Kingston. And you're so right. It's so quaint when you think back to it. It's also surreal. So the facts of some of these stories, like roping off the cherry blossom. So one of the stories we talk about in this book is a case that we were working on at the Canadian Constitution Foundation. It involved a man named Robert, who was frustrated as a gym user and a supporter of small business. A lot of his friends ran small businesses. He was frustrated with these sort of never-ending lockdowns. I think we were on our third or fourth lockdown in Ontario. And he decided to go and protest. He wore a mask and he went by himself. He wanted to start his own protest to say end the lockdowns. And he was charged under, I think it was at the time, the stay-at-home order. And I mean, the idea that someone protesting or standing outside alone with a mask, expressing a political view, poses some type of public health threat, it's just absurd. And so we wanted to use this as an opportunity to challenge the broader lockdown provisions. But in the best interest of Robert, the charges were dropped. So obviously that's the route that we need to proceed with. But the result of it procedurally is that you don't get a precedent. You don't get to challenge the broader law, which is really what the problem is here.
Well, and you've also done something really interesting, Joanna. Instead of organizing it chronologically, which I think probably would have been my instinct as a writer, you've gone by basically sections of the charter and by individual rights and freedoms, from freedom of assembly to freedom of movement, freedom of expression, all of these things. And I think it's easy to just look in general in the abstract or in the amalgam and say rights were violated. But when you go through and point specifically to how and which rights, it's a very powerful case. And let me ask you just on religion alone, because, the government's defense of its restrictions on worship ceremonies and services was that, well, you have the right to, be a Christian, you have the right to be a Jew, you have the right to be a Muslim, but, this is just extraordinary times. But for people of faith, that is the government telling them how their religion must be practiced. I mean, you look at with Judaism, which has very specific guidelines on the number of people that need to be a part of prayer. Government was saying its edicts matter more than these things that we supposedly have a right to define ourselves.
Yeah, absolutely. And we talk about in the book that, so for example, because of these, unprecedented restrictions, it brought out some of the frailties in the law itself. So for example, freedom of subjective belief is extremely strongly protected in Canadian law, but freedom of assembly has much weaker protection. And most of its protections are in the context of like labor union strikes and things like that. And so it was quite jarring to religious Canadians that the government gave such short shrift to the value of in-person worship. I was actually at a conference in the UK this past summer, and I was told that in London or in England at some point, gathering limits were set at 5 people. At least in Ontario, they were set to 10 people, perhaps in consultation with the Jewish community that would have let them know the minimum amount of people needed for a minyan. Having that aside, there are churches in Canada that are important community hubs for particularly for new Canadians, which elderly Canadians rely on because participating by Zoom isn't an option for them. And you really saw that the government was just happy to say, well, you can just log on to Zoom and there's no violation to your religious freedom. The government actually contended in most cases and was countenanced by judges in many cases, that these strict restriction and gathering limits didn't even engage the right to freedom of religion. And you can read about some of those faith communities in the book.
Yeah, and I would also point out, I mean, at the early days, there was a much different attitude. Like I remember when the Ontario government was actually taking a bit of guidance from the Church of God in Aylmer, which was the first one to really try to make drive-in services a thing. And then you fast forward a few months, and the government's having the doors locked and putting millions of dollars of fines down. So
and had police hiding in the bushes observing the congregants.
Yeah, and I actually had, there was one report that was handed over in Discovery in which I was named as a person of interest in the police's investigation of that, because I had interviewed the pastor and they were suspicious that I might attend the service. So they had like preemptively put me on the person of interest list, which was quite an honor. I had never had that before. I would have preferred it to be about something I did rather than something someone thought I might have done. But that's the insanity here. And I wanted to bring up another dimension of this that I had almost forgotten, and it was seeing you cite me that I remembered this. When the government of Ontario had tried to give police the power to stop and question anyone who was outside their home about what they were doing. And very gratefully, every police department in Ontario, except for the OPP, I think in the next couple of days said, we're not going to do this. But like that would have seemed insane if you had said in 2019 that was at all something a government would direct the police to do in a province.
Yeah, you did some really great reporting on that. I think you were the person who was quite literally counting which police.
Well, I was like cold calling them all. I spent my weekend doing that. Yeah,
great work, Andrew, and it's very valuable. And it's very important that we have a record of that. The reality is that police are the ones who need to interact with the community. And, I'm generally skeptical of police power, but I know police as well. And I know that for the most part, police want to have a good relationship with their community and have worked hard to develop a relationship of trust with the communities where they are policing. And they are not interested generally in stopping mothers taking their children on a walk to a playground, which is what that stay-at-home order was going to do, combined with that police authority to stop people. And I'll point out that this police power to stop people and demand they identify themselves and explain why they're outside their house is very similar to a policy that was controversial in Ontario called carding, because carding had resulted in a lot of police interactions with racialized communities in particular, who are generally over-policed. And the government created a policy that they would no longer engage in carding. And there were constitutional concerns around that policy. And in fact, it is so similar to what was announced. And what was announced during the pandemic was actually more extreme than the carding policy. That everyone sitting at that cabinet table would have known how similar this is to carding. And in fact, we know from reporting it was from the CBC, they found they had spoken to someone who disclosed that in cabinet, the Attorney General, the provincial Attorney General, had warned cabinet that this policy is likely unconstitutional. And cabinet and the Premier, Ford, proceeded to enact it anyway. And I think that there's real concern that there's bad faith there. The bad faith is that they knowingly enacted an unconstitutional law, and they did it because they wanted some short-term gain, and they knew that any judicial oversight over that would not be heard in time before this temporary measure had been repealed. And they would avoid any judicial scrutiny. And I think that that's bad faith, and it's very, very concerning. I mean, there's some relief that the police said we will not enforce this, but it shouldn't just lay with the police to say we won't be enforcing unconstitutional laws.
I'll go back to you, Joanna, just as we wind down here, because the subtitle of the book, How Canadian Government Responses to COVID-19 Changed Civil Liberties Forever, is a lofty one. And I know in your conclusion, you actually are rather forward-looking about this. But I'll ask with a bit of trepidation, because I don't want to know the answer, as I think I know the answer. Do you think these changes have been for the better or for the worse? And I'll just add a bit of an asterisk there. When all of the legal procedures have been exhausted, we have the definitive ruling. Do you think that we will end up with fundamentally a less free country than we had going into COVID?
I think we have a legal system that has shown how effectively it can obfuscate answering the question, with the declarations of mootness, with the deference to government evidence. We were talking to another interviewer who found it remarkable that a lot of these issues weren't dealt with under Section 1. So yes, we can acknowledge there was a rights violation, but maybe under Section 1, which is the justification clause, maybe you can say in public health emergencies it was justified, but at least to acknowledge for the record that these were rights violations. So we really have seen all of the ways that judges were able to wiggle out of telling the truth. Now, I will sort of conclude my remarks on a more optimistic note, which maybe I'm a little bit more of an optimist than Christine. I think it depends on us. I think it depends on the culture that we build. I think it depends on our collective understanding and our collective assessment of whether this was good enough, whether we think that if we have charter rights, which were, agreed to democratically, whether they should mean something. And if we understand the sort of fiasco that happened and will hold future governments accountable, just out of sort of shock of how abysmally our culture during the last pandemic failed. I think that there could be hope, but it starts with looking in a sober way at how we actually fared.
If I knew that you were the optimist of the two, I probably would have reversed this. So we get to end on Christine's dour note, but Christine, or maybe you do have a less dour note, but I'll give you the last word on this. What's the forward-looking takeaway you have after writing this?
I'm pessimistic. I think not only did the courts do a terrible job protecting our rights, I think people have just shoved that memory away and forgotten it. And I think that I'm very concerned about whatever the next crisis is. We've now broken the glass on the Emergencies Act. It could be used again in the future. That our culture of civil liberties has been permanently damaged because we've seen how easily people have come to justify huge intrusions into their rights. I think that we're in a very dark time politically in our discourse, where disagreement is not tolerated at all. I'm completely pessimistic, and I'm very dark. I'm in a very dark place, Andrew. But that's why you definitely should have ended with Joanna. But yeah.
Well, I'll say this to try to put a somewhat optimistic flavor on it, is that you have to diagnose a problem to fix a problem. So even taking the approach that you have, Christine, and that both of you have through this book, I think is essential to rectifying it, because there is, in a lot of cases, a political response available. And I was mentioning earlier the private members bill in the House of Commons today, again, may or may not pass. But, if you have a change in government and the government is saying, this should never happen, I will not do this, we could perhaps try to normalize civil liberties again, but I realize the courts will always remain a bit of a wild card there. Nonetheless, it is an incredibly, incredibly important book. I was very honored to be able to write a small blurb for you, and even more honored that some of my work helped you put it together. It's called Pandemic Panic: How Canadian Government Responses to COVID-19 Changed Civil Liberties Forever. It's by Joanna Barron and Christine Van Geyn, and you can also read a bit of their work in C2C Journal this month as well to get a bit of a sense of what the book holds. Joanna, Christine, thank you so much, and well done with this.
Thank you, Andrew. And the book's available on Amazon right now for anyone interested.
All right, wonderful. Yes, do head over there. And last time we had an author on, it spiked up in the numbers. So I'm hoping we can replicate that here. Go to Amazon and check it out. Joanna, Christine, thanks very much.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.